Someone make it make sense.
Probably a couple.
Hello, guys. We have the only fan here. Court was late to start. So we are here, though, for this motions hearing. You are unmuted. And we're going to start with the hearings. For anyone who missed it, they have seated a jury, and opening statements are expected to start on the 22nd.
Yay. All persons have any business before the Honorable Beverly Kearney, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Kearney. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Lallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Lallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth
Spencer, welcome.
and objected to by the defense would result in the destruction of metadata.
I'm going to make
We have since provided the court with an affidavit.
I'm going to make a command for the Ponards. I don't know why. I just haven't made one yet. It's like we have so many commands and we don't have anything for the Ponards. I'm going to fix that. I'm going to write that wrong right now. Welcome Spencer as well. Candace, Happy Annie.
From our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence.
Let me back this up. They're talking about the Lallyport, right? This is still a thing. We're never done with the Lallyport. I just love that. Speaking of Ponards, officials walking the dogs. If I recall, official has 6 dogs, maybe 7. Shout out to Knucklehead, Candace's cat. So this is going back to this whole thing where they sent the dude over to do the Lallyport videos, and then they weren't there, and instead they were on that detective's home computer and all this, right? So we're back there.
Would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive.
Right.
That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
All right, Hank Breenan.
It seems the defense characterization
Oh,
that's
Lord.
forensically sound.
Lord have mercy. Lord help me. Guys, it's early for the goat. It's early for the goat. And yet somehow, Mother of God.
It seems the defense.
Alrighty. I'm about a centimeter away from stabbing my eye with the goat ear again. This time on purpose. Guys, Breenan, y'all. Whew. It seems the defense. No. Dude, the melodrama and the annoyingness of Breenan. And his command still doesn't work. Let's double check.
Characterization that's forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant.
Pete's sake.
And it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in that request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had
That's
asked
a loud
defense
car.
counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view?
You're talking about the jury view.
We haven't talked about the logistics. I'm happy to do that. I don't think that's a very lengthy conversation between Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be.
New
for us
command.
to- Obviously.
Welcome,
the jurors would be
Carla.
Transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats. By
Right.
distance.
Interesting. Anyone having Murdoch flashbacks? They were on the same bus as the jurors. Really? Hold on. I don't believe that. I literally, are my ears deceiving me? Hang on.
Obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. as I stand here, I can't remember if we were on we were not on the same bus as the jurors.
Yes, we were.
We were separated by.
I that strains credulity for me. Like, what? No way. What?
By
Right.
distance. That would, I don't know that that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can.
No kidding. What are we doing? What?
Provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated.
Well, yeah, but also the attorneys were not on the same bus as the point is that the attorneys should not be on the same, or the defendant for that matter. No, they shouldn't all be on the same bus. Why are we on the same bus? Like with Murdoch, the only issue was like Miss Becky was on the same bus as the jurors, but that's completely different than the defendant or the attorneys. What? What? I mean, you can't have them in the same vehicle as the jurors. That's insane. And I totally get, yeah, he was in custody, right? But you can have them in a like the jury knows that they're not supposed to talk to each other, right? That's not a secret. They know that. They're told that if you're in the elevator or you're in the hallway and there's an attorney that walks by and they stare away from you like you've got the plague, don't take it personally because they cannot even lock eyes with you, right? The jury knows that. So to put Miss Reed in a separate vehicle that's like not a jail car, right? Just like a regular car is not going to look, they're not going to assume she's in custody. I would not think, right? And Murdoch didn't go to the view anyway. So, but his attorneys and like Judge Newman, they went and they took separate vehicles, like non-jail vehicles, obviously. So, right? They're acting like they're on Magic School Bus. Yeah, that is so wild to me. Like custody or no, like if I were a juror, I would be floored if I got on that bus and there's the defendant and the attorneys given all of the things that they're not supposed to be doing. Budget cuts, sadly, no. The budget that they are willing to spend on prosecuting this case seems to know no limit. So I just changed Brennan's command and I censored it. Let's see if it works. We know that Nightbot can be fickle, but maybe that'll work eventually. So we do have a command for Breenan. It's just not worked yet. But you know, there was that one time where Franks's command wasn't working, and then she, as to be funny, she put her command and then she like put damn it afterwards and it worked. So let's try that. We're just gonna try. Thunder! It's the first time I'm hearing of it. If you're talking about the Magic School Bus situation. I love that idea, Spencer. Thank you for that. This is the first time I've heard of this ever. Happy to see you, Fender. By the way, check out the members only from last night. You will be glad you did. I think so far you're the only person here that that wasn't in the chat right now that wasn't actually there. You will love it, Fender. You will love it. Happy Annie doesn't mind. You know, I appreciate that. Look, there is nothing wrong with finding one less thing to be outraged about when it comes to this case. Nothing wrong with that at all. I applaud you. I applaud you for that, for sure. See, the thing is because we're like 13 hours difference, I don't know how to interpret this, Fender. Franks is here. Literally, I was just talking about you. That is so funny. Were your ears ringing or burning or whatever it is? I don't know. Are you talking about the members only, Fender? Or are you talking about this? And which morning? Whose morning? Franks. By the way, guys, Franks is deep diving the Twin Flames. So we love that. Oh, the bus thing for Murdoch. Does the morning matter? Just call me Angel in the morning, baby. You guys remember that song? Every morning there's a da 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 da. Songs about morning. Anyway, so Breenan's command is still not working. We'll see. To quote The Room, we'll see about that. Spencer, you might be the only one that will get that reference at this juncture. Long pause. We'll see about that. Another long pause. Dramatic music. We'll see about that. And I'm trying to do the voice the way that he does. Anyway. Oh. AM as in Alex, not time. Oh, for fuck's sake. Well, you guys, that's so great point, Fender. Thank you. That's my B. That's my B. In Murdoch, this is Murdoch. All right. Okay. So in Murdoch, Becky was on the bus. Miss Becky was on the bus with the jurors. Like the court, like the bailiffs and shit were on the bus with the jurors. So that included the clerk of court, Becky. But the attorneys and Judge Newman took separate vehicles because obvious reasons. And Alex, I don't think even went. I haven't had a chance to talk to her about it yet. I'm sure she is relieved. I would hope she's happy about it. I can't imagine she wouldn't be happy about it. Yeah, then we're back. Now she says we're back to first time ever. For me, yeah, I've literally never heard of this. Never heard of this. Never have I ever ridden on the bus with the jurors if I'm an attorney. All right. Let's see what else is in store here. Yeah, whenever you have a chance, you'll be glad you did, Fender, seriously. And all the songs are time-stamped, but it's not long. It's not long. And you can skip the first couple minutes, while we're waiting for the stream and jump to where the concert starts. But you will love it, honestly. The theme is Anthems for Social Change for anyone who didn't see it. And it's really, really, really powerful. Everything from, Marvin Gaye to Latin tunes to Zombies by the Cranberries. They did a Ukrainian folk song, all kinds of stuff. It was really good. Regina Spektor. It was really powerful. The students did an amazing job. No. It wasn't me. I can't. It's at Elon University. I'm not a student there. It was my mom's concert. Well, her students, it's the group that she does, but I explain it in the live stream what it is. And my mom introduces it and then it all makes sense. It was. Okay.
Just be there and able to observe.
It's really good concert.
Last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense.
Why should they? Why? Hold on. That's her reasoning. Why can't the Commonwealth be in a separate vehicle, though? What?
Be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors.
Oh.
We need defense counsel.
Why?
One defense counsel can go in a car, then
Is the solution here not obvious, though?
separately with Ms. Reed,
Why do we have to do it magic bus style?
and the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
Thank you, Annie.
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide,
They want it, right? You want the vehicle there at the time?
We do.
if they
Oh my God. So the defense is like, we want the vehicle there. And Breenan's like, no, it's going to be unfairly prejudicial to them. It's like, how do you know better than them what is prejudicial? Lord, what? Help. Thank God Bev was like, they want it. Oh my God.
motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense.
You decide that.
They want it, right? You want the vehicle there at the time?
We do.
If they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway?
Oh God, we're already at sidebar. Did everybody see Judge Bev's Barbie doll thing. Let me see if I can pull that up while they're at sidebar. Even if you've seen it, it doesn't matter. It's worth seeing again. This Candace says the stupidity hurts my head. Agreed. Just pulling this up. There's Karen's parents. Da, 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 da. I've had that stuck in my head. Okay. By the way, I have a new Jeff emoji ready to go when we have enough members to where I unlock new emoji. It's Jeff making a really Durple's face. It's going to be amazing. I'll show you guys that after this picture. Wait, where is it? Oh, yeah, I can just go to next. Okay, so hold on. Let me just unshare, reshare. They're at sidebar. So here's the, for anyone who missed it, here's the Judge Bev doll. Anti-Judge Bev, Queen of the Cape. I'll allow it. I need the Weekends edition. And what's really funny, if you look closely, the little thingy to smash the ice is like a rolled up U.S. Constitution, because it says we the people. She's got her White Claws. She's got some like lemon drop shots or whatever, I guess. And then on the side, shut the fuck up, Mr. Jackson. This is funny, Miss Reed. Mr. Lolly, do you object? And then look at this part here. Look at the little heart with the ARCCA dude. Crash Daddy. Oh my God. Everything about this is amazing. And then here is the Durple's Jeff thing. Actually, I have one. The one that I have for the emoji has the background removed, but this is the original picture. But the emoji will be just this, just him doing this face. So there you go. Yeah, they're still at sidebar, but we will zoom past it. Fender, I don't have a stage. If you're requesting a violin performance, I don't have a stage. Okay. However, what I will say is this. The closest thing that we've had to this on live streams is during the Lori Vallow trial, when they're on lunch break, there was a day where Court TV was playing this elevator music during the lunch break, and I got out my violin and I improvised along with the Court TV elevator music for like 30 minutes. And then I took songs on request. I played a bunch of Disney songs. I played some other songs until Court came back. So like that happened. That could happen again any day. All right. I mean, I just use my computer for live streaming.
All right, so on the defendant's list, I don't understand the motion regarding.
Fender's asking, since when does Kearney go to sidebars? Since they filed that motion maybe 2 weeks ago, that she be able to go to all sidebars.
Dr. Welcher, because that's been
I can do all
decided.
this.
So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank you.
Your Honor.
Okay. So
shout out to Mr. Alessi, by the way, it's been confirmed he's been in this chat. Like that was confirmed. That was him. He's been here for several Karen Reed live streams. He was also here for a Koberger live stream. Also we have his little clip here.
Hard as a rock, freeze thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
When I say it's been confirmed, it was confirmed through EDB because EDB had the same person and confirmed it was him. And then Miss Mandy, shout out to Miss Mandy, was there for that EDB live stream and passed it along to me without even knowing that he'd been here. So he was here first. Anyway, yeah, so like what it was happening, what it seems like was happening was he was like making the rounds, right? Like he was here. I mean, he was here in the chat for like long periods of time chatting with us. Like literally when I thought it wasn't him, I made the command. We watched the Waterfall Get Low Canton style music video. I played him all the funny clips. I thought it wasn't him, you know, and he was like, I love it. That's so funny. And I was like, sorry, you're not in the music video. I made it last year and you weren't on the case yet. And he was like, that's okay. I'm new. And we talked about music and all this stuff. And he was like engaging with everybody in the chat and like for a long time. And then he came in for a Coburger live stream and was like, I don't know anything about this case, TLDR. And I'm like, okay, here's the rundown, you know, and I didn't think it was him. However, there were at the time some people saying it's really him, but I didn't believe it, right? Because like, why would he be here? Yeah. But then Miss Mandy, who's his girlfriend, who wasn't there for any of those live streams, was watching EDB just recently. And he was in EDB's chat, and EDB said on the live stream that she had like confirmed that it is really him. So they must have gotten in contact or whatever. And so the way that it happened was Miss Mandy was in the chat for a recent live stream here. And she's like, oh, guess what? Mr. Alessi like was at one of EDB's live streams the other day. And I was like, oh, is it really him? And she was like, yeah, EDB like said it was really him. And like something like that. But then I was like, wait, like, so like, I was like, wait, I guess. So I thought that Miss Mandy was there when he was here in our live streams and that's why she was saying it. So it was just funny when she was like, wait, he was here. And I was like, yeah, he was here. Anyway, so that's the whole thing. I can't say I confirmed it, but what I'm saying is that EDB confirmed it, unless there's more than one Robert Alessi that's engaging, which is possible. It's possible, right? However, the thing that made me think that it could be him, and I'm not the only person, I think it was also you, Happy Annie, that said the same thing. When I asked what his favorite music artist was, this is one of the first times he was here for a live stream. I asked who his favorite musician was or what type of music he liked, and he named John Lee Hooker. And I didn't know that name. I looked it up, and then that resonated with me as, yeah. And at that point, I was like, it's probably still not him, but like, that seems legit, right? Because that's like a old school blues musician. And anyway, so Fender was in the chat too. Okay. Were you there when EDB said it was him? So how does he have the time? The one thing I'll say is this. It's clear that through this process, they have been really, really, really putting a lot of focus on having their finger on the pulse through social media and stuff like that. Because like, for example, through voir dire, that's what's been going on with these jurors because they've been looking at these jurors' social media. So, you know, while it does, like, you know, it could be that this is like a way of seeing what people are thinking about the retrial. You know what I mean? Happy Annie says that did it with me. Okay. Oh, you were here in chat with the music discussion. Okay, cool, Fender. Cool. Yeah. So you remember that part. Okay. Yeah. That's funny. So, you know, I'm just, if it's the same, like, I will just say, EDB wouldn't say she's verified something if it's not verified, right? So for what it's worth, the Robert Alessi that was in EDB's chat, which I think happened when I was live streaming something else, so I wasn't there, but the Robert Alessi that was in EDB's chat, if she said she verified it was him, I fucking believe it. Like, there's no way around that. Like, that's a given. So that does mean he has a YouTube page. That does mean he goes in chats at the very least. So we can say that at least, you know, is verified. Is there more than one, you know, like, actually there's probably a way to figure this out. Let me just go see if there's more than one with the same picture. I'm seeing a number of Robert Alessis, but they're just the letter. They're not the picture. It's not the same person. I'm thinking, let me just see. Anyway, I can keep looking for this while we watch the hearing. And the thing is I thought I had it timestamped too when he came on the live streams, but I went back and looked and I couldn't find it. So maybe I didn't timestamp it. Anyway, I'll keep looking while we watch this.
Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think
Okay.
it's too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
It's not fair considering she's admitted all these different Commonwealth experts without voir dire, even though they're like not qualified. Here's Mr. Alessi.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right, that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report.
Oh, God.
The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition, and the whole topic of pattern recognition was well established through Dr. Russell, so Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on.
Okay, this is fair. This is fair is fair. What's good for the goose is good for the gander. Let me just explain what's happening here. So in the first trial last summer, spring, summer, it was like literally this exact same time of year, basically, is when it started, right? Judge Bev made this ruling. And I remember this very, very well when she said it is well settled Massachusetts case law, right? That like, if you are not a medical doctor, you cannot opine as to causation of an injury. Okay. That's what she said, that it's well settled Massachusetts case law. Now, whenever she says that, she never cites anything. Go figure. I will just tell you that I heard a lot of people repeating that, assuming that she actually had case law. I was like, this is Judge Bev law. It was clear to me that she was just saying this because that's what she does. When she wants to side with the Commonwealth, she just says shit and says this is well settled law and then never backs it up. That's what she does. And I thought to myself back then, this will come back to bite her. I thought to myself, I wonder if what's going to happen is at some point the Commonwealth is going to be trying to submit somebody, right, and have them opine as to causation, and they're not a medical doctor, and then she's going to have to flip-flop, right? And it didn't happen during that trial, but what did happen is just here recently, pre-trial, right, as we head into the retrial, it happened. And that's literally what he's talking about. It literally happened when the Commonwealth wanted to submit their expert for the dog bite shit. And he is basically a dog trainer. And for him to opine onto causation of human injuries is absurd. He's not even a veterinarian. It's laughable. It's sad, honestly. He's not even a veterinarian. It's a joke. It seems like a joke, really, when you're like, what? Like, sure, he could be an expert on dog training, but that's literally not what we're talking about. And that he's going to be able to opine on the cause of wounds on a human. And she's Judge Bev. I'll allow it. That's why it was on the fucking doll, the Barbie doll. I'll allow it. Not even of voir dire. Not even of voir dire. It's like, do you laugh? Do you cry? Do you scream? I don't even know. All of the above, probably. It's awful. This is not okay. It's not okay. Okay. And so then the defense wanted to bring in a rebuttal expert. Now that the standard has changed, according to Judge Bev, right? We're no longer using Judge Bev law from last summer. And they want to bring in Dr. Wing on rebuttal. And Judge Bev denied him. Of course she did. Of course she did. Oh. And he's more qualified than the Commonwealth's dude. I forget it. Dr. What was his name? The dog behavior dude. I don't even remember his name. But anyway, so what he's getting to here is the point, which is, look, it's one thing that she made up case law, but now that's what she said. She said it. She said it. She said it. So she cannot make it apply to one side and not the other, even though it doesn't exist in the first place. That's where we're at. We are in imaginary land where Judge Bev makes up case law. Okay, fine. We're going to go with that. But you can't just make it up and then change it depending on which party is bringing in an expert. This is insane. Yes, well settled law on her head. Yep. It sounds like a joke, this trial in a nutshell. Yes. Spencer, fair point. If he's a dog trainer and he's an expert in dog bites and he's the worst trainer of all time, literally fair. And that's a great point as well, right? So I take it back. He shouldn't even be qualified as an expert in dog training. Okay.
The whole topic of pattern recognition.
So like basically it's just, he's got to go with what's good for the goose is good for the gander instead of calling her out because you can't call her out, which sucks. The amount of restraint it takes to practice in front of this judge
Was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can.
Dr. Crosby, that's the dude. That's Dr. Crosby, aka Dr. Crosby. That's the dude that we will all laugh at. We will laugh at him And then we will also laugh at Dr. Gilman, who's going to come in and say the ground was hard as a rock. Those are the two. Well, there's probably others, but those are the two big ones from that big motions hearing where they fought over these experts. Not even fighting, because just Judge Bevel housed them in for the Commonwealth. But it was these two clowns, right? We're about at a level, you guys. Murdoch, Mike Sutton, the two gray boys, right? 5'2" ninja assassins. We are about at that level. I don't know that we are there yet. But in terms of the clown show, that is Dr. Crosby and Dr. Gilman and the hard as a rock, and he didn't even use a penetrometer to determine it. He didn't even use a penetrometer. You guys can get one for $40 on Amazon. I looked. Pocket penetrometer. Anyway, yeah, armpit, same. But as far as experts offering just these crazy ass, like, what are we doing? Like, we are almost on Mike Sutton level with these two. At least coroner armpits was a coroner, in which case anyone that knows what the deal is with coroners should have low expectations. Like, that shouldn't, like that. If that happens again, I will not be surprised. It was only surprising the first time because I didn't understand correctly that a coroner is literally no one with no training. And it's just like an honorary title, like, for the sake of tradition. So now I'm like, okay, right. But like, when you've got an expert witness that comes in and that's a big deal, right? There's a lot of steps to get an expert admitted. And it's just,
Opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby and understanding the court's schedule and other matters. Given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a Sir rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that.
That's the court feed
of Dr. Crosby.
That's the court feed.
And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report,
it was.
We would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
So that's another motion. That's what we're going to hear now.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to.
I don't know what's going on with the court feed. Fender says, do you think these guys finish at court and go scream into their pillows because drinking would lead out? Yes, absolutely. I do think that. Also, for anyone who was there for our movie night, can you guys appreciate why I like, and for trial, I love good lawyering. I love the legal argument. I love the 4D chess of it all. I equally love the shit show, right? And for those of you guys who understand what the B movie thing is, if you were there for the movie night, or if you just know what B movies are, you can see there's people that love a good shit show, right? And to those people, B movies are going to be awesome, but I will be honest, there's nothing like trial. Like, really, there is never a shit show like live trial. And so my favorite, that's why I like Murdoch. Murdoch I love for so many reasons, but it does such a great job of combining really like good lawyering. Like that cross exam of Alex is on. I'm going to start crying talking about it, which is ridiculous, right? But anyway, it's on another level. I mean, there's really good lawyering. But there's also the shit show, right? And so my favorite trials have that balance, right? But even hearings can go, I mean, it's like, there's been some hearings in this case where it's just like, holy fuck. Like, anyway, yeah. So just wanted to point that out too. And 100%, right? No, it's the court feed. Defenders, the court feed's glitching. And yeah, so like, The shit show, I'm not talking about the judge. I'm not talking about the shit show as in like, I'm talking about the shit show when it's funny. You know what I mean? Judge Bev being completely biased is not, I don't count that. That's not shit show. That's that doesn't count as funny shit show. Right? That's different. So yeah.
Because
That's not
Go ahead.
funny.
Just move on.
yeah, so my request would
I'm talking about like once there's nothing else that can be done and like you get past the injustice of it all, this shit is fucking funny, right? Like this shit.
Hard as a rock, freeze thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
Your Honor, I can't do this in 2 minutes.
You know, this is why we watch. This is why we do this.
be that a determination on
Yeah,
whether or not
this is the court feed. I don't know. Let me see if I need to try a different court feed. I don't know how long it's going to glitch like this. Let me just go forward a little bit and see if that fixes things. I don't know what's happening.
the discussion. So in conclusion, Your Honor, we respectfully request to have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report
Right.
of of
Okay.
Lieutenant Wing.
Right.
Thank you, Your Honor.
It seems okay now.
All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration,
Right.
I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent.
This is craziness. The shit show, the two Grey Boys, right? The 5'2" ninja assassins shit show. This is crazy though.
For reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites.
Of course you're not.
But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I
No.
think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of
This
any.
is gross. She's trying to split the baby and make it seem like she's not as fucked up and biased. Because here's the thing. So what she's saying is, look, dude, this is so gross in my opinion. This is my opinion. What she's saying is you can't say that it was definitely not Chloe, which that's a step in the right direction, but he shouldn't be able to get into causation at all as per her own rules, law that she made up. The way that you cure this is this. Either Dr. Crosby cannot testify to causation of the injuries on John McKee's arm. That's one possibility. Or he can testify to causation, but so can the defense rebuttal expert, Dr. Wing, also can. That's it. That's how you fix this. It has to be fair to both sides. It doesn't fix it to say he can testify to causation, but just not specifically about Chloe, and the defense still can't bring in their rebuttal expert. Doesn't fix it. But she's trying to make it sound like she's fixing it, like she's being fair. Do you guys see what I mean? Do you guys see how this is literally the opposite of fair, but she's trying to make it seem like she's restricting the Commonwealth in some manner when really it's not? It's like gaslighting. Ugh.
This either was or was not this particular.
Yeah, we got the goat. You got it, Fender.
Dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds show to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
No, they're not trying to say it came from Chloe specifically. In fact, they were not allowed to say that. Look, here's the other thing. He's bringing up another issue, which I don't even know if he wants to be doing this because this is dumb. So the defense has been not allowed to say these bites came from Chloe. They've not been saying that, right? That happened last summer. So they're just saying these came from a dog, not that it came from any specific dog. But then the Commonwealth wants to come back and say these bite marks did not come from Chloe. It's like you're arguing against something that wasn't argued in the first place. It doesn't make any fucking sense.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Okay.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Right.
You want to reply?
That's literally what I was just saying, that there shouldn't be any argument made about Chloe either way. Like, leave Chloe out of it, right? Like, in terms of specifically, like, Chloe can be brought up in other ways, right? Like, they're going to know that Chloe existed, right? Just like in the first trial. But no one's going to argue that, or he's saying no one should be able to argue that the teeth are Chloe or aren't Chloe. And I agree.
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there being discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which
No,
is why
you don't
originally I was going
have-
to hear this motion to reconsider
Oh my God.
after the defense presented their witnesses. So, all right. Thank you. The substitute chemist. Is there any objection to the substitute
I don't think
chemist?
that's going to be a problem.
Commonwealth's motion is 663.
No, Your Honor.
Okay. So
No
Jim,
problem there.
63 is allowed.
Yes, Your Honor.
Oh, look, guys, they got a bigger TV. Remember when they asked for the bigger TV? That looks bigger. That's what she said.
So you both have motions that are similar regarding it's
I mean, I don't know. It's not that much bigger, but it looks a little bit bigger.
the Commonwealth 669 and Defense 670, I believe. It's about the audio visual
Good question, Spencer. So for anyone that doesn't know, I can almost guarantee you and bet your bottom dollar that Spencer is brand new to this case and hasn't said so. Bless your heart, Spencer. Like, we love you. He picks up on things really quickly. And this question is great. But is Chloe assumed or implicated or implicit? So Chloe, the whole thing in this case. So Chloe was a canine that failed out of canine school, basically, right? And like, all we know is like there's a lot of sus things about this case. And the thing that is probably for me the most sus of all with Chloe is that Chloe had issues where she'd like attacked people before. Like that is on the, like, that's evident there. That's coming in evidence, like the human she attacked. But like also right after John O'Keefe died, they quote unquote rehomed her, right? Which everybody, the whole story, dude, this is insane. The story was that she was sent to go live on a farm in Vermont. And apparently that is actually a colloquialism for like putting the dog to sleep. And that's what people say. So, and the testimony was so weird at the first trial about Chloe, where it's like the way that the family talked about the dog was like, they said it was. And it's like, what? This had been their dog for years. It was their family pet, you know, whatever, you know how it is. And like the way they talked about this dog was very weird. And it was like, we just sent you to go live in a farm in Vermont or whatever. And like, there'd been no sign that Chloe was alive, right? So it was, some people maybe seriously thought Chloe was dead. Maybe other people were joking. I don't know. But it was like basically this whole thing of like, where's Chloe? Like, we have no evidence. We have no proof of life, right? Well, it's not until maybe January or February of this year. Now they've got a new prosecutor on the case for the Commonwealth, Mr. Breenan, right? And literally crickets about Chloe, okay? Up until they're at this hearing when Dr. Russell, who's the dog bite expert for the defense, is there for this hearing. And he's basically cross-examining her, which is not how it's usually supposed to go for a voir dire. And Breenan for the Commonwealth, right? Like literally out of nowhere. This is why I think he made it up, because literally it was only to try to like one up her. He was like, well, did you know that we have molds for Chloe's teeth or something like that? And I like lost my mind. I was like, what? I mean, it wasn't just me. Everyone lost. We collectively lost our minds. Like, say what now? It wasn't like there was something filed that's like, oh, Chloe exists. Here's where it was like, there was like literally nothing until only an argument to try to one up Dr. Russell. Is he like, we have a mold of her teeth. And it's like, huh? It came out of the blue. Dude, it was so sus. And there's still nothing to support that there's anything reliable about any of this. The Commonwealth says, okay, that they found Chloe and they tracked her down. They don't even mention that they went to Vermont, but they would have had to have gone to Vermont, right? Like there's so much missing with this. And it's funny because the defense isn't even chasing down this rabbit hole because it's so stupid, right? Like they're just like, we have an expert who took a mold of Chloe's teeth. Even if Chloe existed, and even if she's in Vermont, even if they went all the way to Vermont to get the mold of her teeth, there's still so many problems with this because it's been so much time that's elapsed that however her teeth would be now would be different than they were then. Like the whole thing is completely fucking pointless. And there's nothing to support any of it. It's just a mess. So that's, Candace says she thought she was dead. So what I can say is this, that when you see, Spencer, the marks on John O'Keefe's arm, they look to most people, myself included, like dog marks. Like the dog bit with the mouth in the middle, and then you had the claws on the sides that dragged. That's what it looks like. And it doesn't look like much else could have possibly caused it. How he died is really still pretty much a mystery. Like, for real. I think that my money's probably still on the fire hydrant, but it's completely clear that he was not struck by a car, which is why this entire thing is insane. So, and the way the Commonwealth has pivoted with their theory is also funny. Spencer wants to believe. You want to believe she's alive? I want to believe she's alive. But as far as her involvement, I mean, it's is it possible? The other thing too would be like, was it that he was already dead and then Chloe was outside and, you know, but the way those marks are, it really looks like if you imagine somebody standing up and putting their arm up to defend themselves against a dog that's going to attack them, that's what it looks like. That's what it looks like. The way that they latch on to the arm, you know, that's literally what it looks like. Now, the thing is those wounds did not cause his death, right? They did not cause his death. Right? It was the head wound and then the hypothermia. So those wounds were superficial, right? Had that been the only thing that happened to him, he would have just gone to the hospital. They would have like given him like a shot for rabies or whatever, maybe. And then like, I don't even think he would have needed stitches probably. They were just abrasions, right? Some of them were puncture. So they just would have needed to make sure there wasn't an infection, but it wasn't like gushing blood or anything like that. Right? So anyway, the whole thing with the only reason it's even being talked about really is because it's like, what happened to him? Really? I don't know that we'll ever know, to be honest with you. I don't know that we'll ever know. I don't think the fire hydrant was ever tested, but like still the myth, the legend of Chloe. That's literally what it is. It is the myth, the legend of Chloe. It is. Yep. It is the myth, the legend of Chloe. 100%. You've got it. You're spot on with that. That's why the Chloe thing is this whole thing. But I agree, Fender. Yeah, really. It's really crazy, right? So like, you know, the defense has their ideas for the third party thing, and they're limited into what they can present for that. But, you know, a lot of us, myself included, well, pretty much everybody, literally everybody who discusses this case says the same thing that at least what I'm exposed to, which is that the defense here is better off not going into third party because the Commonwealth's case is a fucking mess. And that's such an understatement. It's just such an understatement. Solo cups. Need I say more? It ends with the solo cups. I remember in trial number 1, when that happened, it's like, why are we here? We're done. We're done. We are done. Go home. Like, this is ridiculous. That's just one thing. It just gets worse from there. So, you know, because the problem, you know, is, as you guys are well aware, like when the defense starts doing the third party culprit, it can end up becoming like a burden shifting, right? Where they almost take on a burden and they don't have any burden, but to the jury is expecting them to prove something. So them not being allowed to get into all this third party culprit, I think honestly, well, it's Judge Bev denying the defense something that they're asking for. In a lot of ways, a lot of people feel like it's a blessing in disguise because they should focus more on the Commonwealth's case as shit. But anyway. Question, Fender says, is $50 a lot of money for y'all in the States? Do you mean spending $50 or making $50? Depends on the context, I think. And I think it depends on a lot of things. Probably also where you live. I need more information. For me, $50 is a lot of money to spend or make, either way.
Aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing?
Questions, offenders is spending money for a therapy session outside of insurance network. So here's what I will say. I think that that's pretty standard in the US for people that are like, that would be standard for most insurance companies and for a lot of people. For me, that my insurance, I wouldn't have that issue because I have insurance that just, there is nothing out of network basically. But I think that for out of network, that is pretty standard. In fact, I think it might even be more. But we'll let some other people weigh in on that as well. Do you do virtual therapy, Fender, or are you just doing in person?
Doing this for the defense, or who's telling me what's going on?
We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
Just
motion.
for the court, the Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense, what you intend to put up?
just a single photograph, Your Honor. I'll provide it to the court.
Yeah, Candace says a lot
Okay.
more. That's what I
Your
thought.
Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we've given them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes,
So
please.
the defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right, how are you going to find this person?
But we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to.
Okay, this is interesting. This is really interesting. This is court theater. This is interesting. This is a whole thing. They need to have somebody who can play Karen Reed when reading of the text messages, guys.
Emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer.
You said the word drama.
Independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right, how are you going to find this person?
Are we going to have auditions? Auditions, casting? Who's going to play Karen Reed in the trial? Dude?
We could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense, but I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
You may have one, Your Honor.
I just have to say, Fender, that is so cool. I'm so curious. That is so fascinating. Is it because there's like certain, I'm just curious, like, is it because you cater to people who have that cultural background? Because I mean, really, I'm just thinking like you could even like if you're doing virtual, you could do like literally people all over, why limit it? You know what I mean? But is this reading thing normal? Nope, sure isn't. But what is normal about this case? But everybody, isn't Fender amazing? So I didn't even know you were doing virtual because I know you've been through a lot of job changes. Is this new with like since you started your own practice? It seems like maybe it is, but this is amazing. And I love that Fender is telling us about this. So I see. I don't know anything about Medicaid. There's also Medicare. I don't know how they're different. Yeah. So, but here's what I will say, like $40 to $50 is super reasonable, Fender. Like that's what I'm taking. If you're talking about people in the US and Canada, from what we're seeing from everybody weighing in, that's really reasonable. So that would be a competitive rate against other, people, you know what I mean? If people are price shopping or what have you. Interesting, Fender. Okay. So you don't limit it. You don't limit it. Pretty recent. Wow. So do you know there's things, I mean, I don't know anything about it, right? I just know there's like these online things, like, what is it called? BetterHelp. And I'm sure you know about this, right? But it just, anyway, I'm sure I love the word of mouth thing. That's also how I get new students as well. And pretty recent. Okay, cool. So Candace is paid $150 plus per session. That is crazy. Yeah, so like there's like BetterHelp and like what is the other ones? You know, where like literally they find you clients from all over the world or whatever, but you probably have to pay them a fee. But yeah, no, 50. So I'm getting from y'all that the $50 is really reasonable. So that would be a very competitive rate, sounds like. Yeah. It does sound like though the $50, regardless of where in the US and maybe Canada as well, is gonna always be a low rate, right? It sounds like. The other thing I will say too is like, I know like the best thing you can probably do, and I don't know anything about how to go about doing this, but like having the most insurance companies that will like work with you is probably good. Like if I were someone shopping around, I would be like, which people take my insurance, right? And but like, because there's so many different insurances that I could see where like the more that you have, and I just don't know anything about how, I don't know anything about how that works. But, and that's a good question from Spencer as well. What is BetterHelp's pricing? Yeah, that's a good question. Yeah, that would be something that would be interesting to look at, Fender. That could give you an idea. If you go to BetterHelp, you can probably just like browse and see kind of what other people are charging in the US. And you could even just like click on it and then you could maybe get an idea to see what they're charging for out an hour, because they probably will be a bigger like seems like they're kind of taken over from what I can tell for therapy. And so they might be like a competitor. Yeah, a good comparison. I agree. Yeah, yeah. Yeah, for sure. Oh, okay. You won't qualify. Interesting. Okay. I see what you're saying. Okay. 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 So it'll always be out of network. Okay. That's good information to have. And that does make it seem like that would be why you want to make sure you have that rate. Yeah, that makes sense. Yeah, definitely check BetterHelp. We will help you however we can though, Fender, because you're awesome. And totally support this is what we do. It's a squirrel crew, right? So we're here for each other.
Yes.
So there's right. So finding somebody to play the role of Karen.
Who's available throughout the trial.
Incredible.
Play that role.
Play that role, he even says.
Yeah. Yes.
Okay, he's taking a moment.
To consult with my colleagues. Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think creates a wrong impression. I think objectively we can have somebody come in who simply reads those text messages.
I think I love the idea of him playing Karen Reed. That's funny.
I disagree gently with Mr. Brennan. That's exactly what
Gently.
the proper protocol is. If Mr. Garino is the one who found it, he's a state trooper, he found the text messages. He was
right.
the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time.
Right.
To have somebody else come in or other individuals come in to act as readers, I think that is not in keeping.
It's crazy.
The ordinary course of presentation of the evidence. It just doesn't make sense to have a reader come in. It seems to add a theater to the text
Yeah.
messages that are inappropriate.
It does.
I don't know who these
It's crazy.
would be, and the text
Now-
messages are admissible
Okay.
because
Well, it's while I'm all for courtroom theater, right? It's hilarious that they're asking for it, but really it shouldn't be happening at all.
they're statement of the party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a
God, what was it recently, you guys? Hold on. There was something recently. What was it? Oh, what was it? Damn it. What was it? Where the attorneys were arguing back and forth about trying to demonstrate something or act something out. And then whoever was on the witness stand, they were like, this sounds like a joke, but it wasn't a joke. They were like, Your Honor, can so-and-so just come down and just demonstrate this and act it out or whatever? And like the witness started to like get off the stand, and then the judge stopped them. What was that? It was insane. It was like, it literally like, how did we get this far into this where everybody's acting things out and playing rules? What was that? I'll have to think about that. That might have been in the South Carolina v. Zachary Hughes case. Maybe. Oh my God, what was that? I'll have to think about it. It was recent. It was recent. Oh man. Anyway, but that's what it's giving me flashbacks to here. But I had another thought. Hold on, let me rewind it. What was my other thought? Hold on.
It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals.
Oh, I
would be.
know why I was thinking it. I know why I was thinking it. Because the only way this could get even more funnier slash not funny in terms of, justice and being fair. Like, in other words, the thing that it reminded me of, okay, here's how I got there. Because I was literally thinking, like, imagine if the Commonwealth was like, hey, I have an idea. Why don't we have Karen play Karen? Why don't we have Karen play Karen? And literally, that idea is literally akin to the thing that I'm trying to remember. It was on par with that. It was on par with that. It was on par with having, and maybe it was the defendant. It was on par with like having the defendant. What was it? Oh my God. Act a scene out or something like that. Like literally that's what the thing was. Oh man, I wish I could remember what this was. And it was like so crazy that anyone was even asking for it. But anyway, the next step would that would be the next step. Like it's like that would be the Commonwealth. Like if they're like, have Karen act it out. They haven't asked for it yet, but just can you imagine though? Like wow. That was very crazy, but that's not what I'm thinking of. I'm thinking of when it was literally being asked of the defendant to like act something out that was part of the crime they were being charged with. Something along those lines. That was insane because it was like they were asking someone else to like act it out. And then it was like, why don't we just have the defendant do it? I'll think of it. It was just crazy that it was even being asked. Again, the example here would be for like as if the Commonwealth, if they were to say, why don't we just have Karen play Karen? It was like that. It was like on par with that. Like imagine that, right? Right? I know. But also just think about how prejudicial, right? Having them act it out or, or in this case, read all these text messages. It's like, it's literally like it's literally making the jury believe that you did the thing, right? It's like, it doesn't get any more real than that, than having the defendant themselves do the thing. So it's like so prejudicial. It's incredible. Even think about. Okay. And do the therapists set their own rates vendor or I would imagine they probably do. No, I was saying if if the Commonwealth were to then take this a step further and ask for Karen to play her own part, right? They're looking for someone to play the role of Karen in the text messages. It's like if the Commonwealth were to take it a step further and say, well, we suggest Karen play herself. I'm saying that notion is on par with the thing that I'm trying to remember that happened recently in a different case. So.
And the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female, or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between two independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. But people talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. It's I understood it to be to take out all infliction, and completely that.
Right. I heard Mr. Breenan say the same thing. I don't know that that's actually what's going to happen.
Right.
This lends itself
Wow.
to sort of a theatrical presentation.
It does.
It's completely unnecessary. And
Yeah.
incredibly objectionable. And then once it's done, it's done.
And the thing is, this is crazy. The thing is why do we need this now? We had the whole first trial. Trooper Green read the text messages. Why? Tell me why.
Consider it.
Oh my gosh, you'll consider it. Mother of God.
Thank you.
Apparently, Candace.
All right. Defendant's motion for specific discovery, paper 638, Jimmy. All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Breenan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay. There's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay. Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Number 5? Yes. With regard to number 5, we also talked about modifying the language. Mr. Breenan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Breenan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness. If they had any reluctance or concerns about testifying, I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay. Thank you. All right. The ARCCA witnesses, motions regarding that. So where do you stand, Mr. Breenan, with what has been provided and what you might think has not been provided?
Okay, so
There are 2 issues. There is
Spencer, are you still here? Make yourself known, because I think if you're still here, you're going to want to know who these ARCCA witnesses are, because they really are hugely important to this case. Let me know. I'll go ahead and play some of this and then let me know if you're still here and we'll do a little quick rundown briefly.
The discovery that we have requested in the past, at this point, I stand unsatisfied with that discovery production.
Yeah.
And then secondly, there is the limitations that should be imposed upon ARCCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025.
Thank you, Spencer. Okay. So here's what's the deal with ARCCA. So ARCCA stands for, I forget what, it's ARCCA. So here's what happened. In the first trial, okay, the feds were doing an investigation into the investigation of this case for numerous reasons. It's a mess, like I said. As part of the investigation into the investigation of this case, the feds, as in the Department of Justice, hired, they do their own third-party thing, right? They had all these people doing the different things. And in part of it, they hired these ARCCA dudes, also known as the crash daddies, to conduct testing to see whether or not it was possible that John O'Keefe's injuries could have come from being hit by a vehicle, which is literally what this entire case is about. Karen Reed is on trial for murder for hitting her boyfriend with her Lexus SUV and then leaving him to die in the snow. Okay. And that's what she's on trial for. And because there's so many issues with the investigation and with longtime corruption for the Canton Police Department and Massachusetts State Police, and there's other cases too, right? They're doing this whole investigation. Okay. And as part of their investigation, part of it involved determining whether or not this was even possible for John O'Keefe to be hit by a car and sustain the injuries that he had. So they bring in these ARCCA dudes, third party. They know nothing about, and they're not involved with this trial. Okay. They're simply hired by the DOJ. Here's what we want you to do. We want you to figure out, could this have caused this? Right. So they do things like they build a cannon, and then they, because the other thing they have to determine is like, what could have caused the break in the tail light, right? Because part of the allegations are that the Commonwealth, law enforcement, right, broke the tail light, like to frame her, right? That's the whole defense. Like they started opening statements first trial with Karen Reed was framed. Okay. So like, how did the taillight get shattered? How did John O'Keefe get his injuries? Like the ARCCA dudes built like a cannon to test if you were to chuck glass, like would it make the taillight break like that? The answer was no. Like then they had like a dummy, right? And then like if under all these different circumstances, right? Like what would happen if the thing was hit and like could it have caused? Anyway, all of their testing was conclusive without any question whatsoever that there's literally no way that any of this happened. Like there's no way he was hit by a car to sustain those injuries. There's no way that the glass broke the tail. Like literally it obliterates the Commonwealth's case, completely obliterates it. And these are third parties that are, this never happens because they're completely unbiased. Normally in cases, right, in trials, the expert witnesses are hired by one side or the other. And so there's, potentially a little bit of bias, right? And it just sort of depends on the expert. Some of them seem to be more neutral than others, but it's expected that they're going to be paid by one side or the other and they're hired to come in and da-da-da. This is completely different because they were hired by the DOJ and they have no bearing on anything with this trial, or they didn't anyway. So, but this wasn't known until like literally halfway through trial, basically. So in the first trial, like halfway through trial, right? That's when the defense is like finally allowed to like communicate with them because there were like rules put on and restrictions from the DOJ as to what those dudes could say because it's like a federal investigation. So like it all kind of happened last minute. So like in trial, like these dudes, they're like, hey, we got these dudes. And so if you're the defense, you're like, here's these dudes that were hired by the DOJ to do this other third-party investigation, and their findings obliterate the Commonwealth's case. They are far and away the most important witnesses for the defense, far and away. And the defense did not have to hire them. And what I mean by that is find them, ask them to find something in their favor, whatever, right? So that's funny, Spencer. So anyway, so these ARCCA dudes, basically, that's it. Like, and so what happened was, everybody thought like, that's it. There's no way like she's going to get acquitted, right? So, but the problem is they weren't allowed in the first trial to say who paid for the ARCCA dues. Okay. So nobody thought this was really going to matter. Like what the jury was told in the first trial was like, they're an independent third party, da, da, da. And like, everyone's expectation was this is supposed to sound like the best possible scenario, the best witnesses that could come in and say something like, whatever they say, you can trust what they say. Right. And then when there was a hung jury and then jurors was speaking out, what the feedback was that the jurors that wanted to find Karen Reed guilty had everything that they could think of to try to speculate as to who hired the crash daddies, the ARCCA dudes. And everything was things that looked sus. Like, for example, they thought maybe it was Karen Reed's insurance company that hired them, or that it was like Turtle. Like basically what some of the jurors interpreted it as, no, it didn't even cross anyone's minds that would have even been possible. Like they worked extra hard to find a way to exclude the validity of these professionals and their credibility. They found a way. The jurors that wanted to find her guilty found a way to be like, oh no, we can't trust them because of it. And it was completely insane. And it was like heartbreaking to hear from the juror that spoke out about this, because it was like, you've got to be kidding me. You've got to be kidding me. How? Like, anyway, so part of what has been going on with the crash daddies for this upcoming retrial is that there were some issues about who was paying them and all that. That's been sorted, I think, because initially they were paid by the DOJ and then the defense had to pay them anyway. But the thing that they're talking about now is like the defense wanted to be able to, because of these issues, right? The defense wanted to be able to say who the third party was for obvious reasons, because the fact that they said, oh, it's a third party, but we can't tell you more than that. The jury took it as sus. So obviously this time the defense is like, look, we want to be able to say the third party was the DOJ, but we don't need to go any further than that. We don't need to get into there was an investigation, because that could be prejudicial, right? Because the Commonwealth was arguing, well, if you start talking about the DOJ, you're going to have to talk about the whole investigation, and it's like, no, you don't need to do that. All you have to say is they were hired by the DOJ, leave it at that, right? So, and of course, even though that argument makes sense, as expected, Judge Bev denies everything for the defense. So anyway, they're still talking about so that's sort of what's going on with the ARCCA. There's some other things as well, I suppose. The Commonwealth is trying to exclude them from testifying completely, which is really funny because all along Breenan here, who you're looking at, kept saying, I'm not trying to exclude the ARCCA witnesses. It's like, yeah, right. I'm not trying to exclude them. Well, eventually he finally did file the motions saying what we all thought, which is he's trying to exclude them. Why? Because literally the ARCCA dudes closed this case for the Commonwealth. It should have happened already. It should have happened the first time around. They obliterate. It's sad. It's disgusting that this trial is even happening. And he's trying to keep the ARCCA dudes out. So there you go. The crash daddies, it's beyond pretty solid. It is, we're talking about the most experts in physics that have literally no dog in the fight or whatever they say it is, bone in the, whatever the thing is, they point blank, and you'll get to hear they are not going to be excluded. I would be shocked if they were excluded. So you'll get to hear them at this retrial, but they point blank destroy everything that the Commonwealth says. It's not possible. It's not science. It's not possible. It's not possible. Right. Exactly, Fender. The jury thought they were insurance people and were included. Yep. So, all right.
Docket 640, Commonwealth's motion to compel reciprocal discovery of ARCCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCCA that would make clear the relationship between the ARCCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date,
Oh.
the court suggested that perhaps we could have
He's
a
still squawking about the discovery. This is crazy.
voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCCA witnesses. There are a number of specific items which we sought in.
I know I'm with you guys asking, hasn't this been settled already? You know, I think that what happened with this is that the Commonwealth filed a renewed motion. I mean, I believe we covered it if it was, unless they just filed something additionally, right? Which is possible. But I do feel like recently there was a renewed motion and I was just like rolling my eyes and probably goading, right? I feel like that happened like maybe a week or two ago, where they renewed their motion regarding the discovery for the ARCCA witnesses. So, in other words, they're just still squawking about it. I mean, yeah, it's the trial that never ends. Yep. That's funny, Fender. To quote John Oliver, every decision is the absolute worst, ketchup or mustard, the N-word. He meant it for Trump. That's funny. That's funny. Yeah. The thing is he's not letting it go about the discovery because listen to what he's asking for. Let's go back to what he's asking for. Okay. Hold on. Because this matters.
They're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense.
Hang on. So he's going through a history of the filings. So we want to, but I didn't go back quite far enough to hear because the thing is this.
Between the ARCCA witnesses and the defense back from its inception. It is important.
Okay. So here's what he's trying to allege, guys. Just to reiterate, and for anyone who's new, he is trying to twist this entire situation with ARCCA to make it seem like they were working for the defense the whole time, which is insanity. It's insanity. It's not possible. The evidence doesn't support that. This is crazy. He's trying to make it seem like the defense and the DOJ are buddy-buddy, which fancy. Imagine that, right? Like literally, what? Oh my God. And that they were hiding this and they were working for the defense the whole time and that there's an issue of candor, right? And so because of that issue of candor to the court, he needs full discovery. Now, the reason why he's asking for that is because he knows it's impossible to get. And here's why. Because the vast majority of the discovery is with the feds and the feds do what they want. And the defense counsel here has literally no control over what the DOJ is going to turn over. And he knows, Breenan knows that what the DOJ turns over is going to be very limited. And it's because he knows that he's like, we want all the discovery because he knows it's impossible, right? And then he's like, if we don't get all the discovery, we have a problem with candor, okay? And so then his solution initially was he was like, we just need the discovery, voir dire. I'm not asking for exclusion. Well, as we'll hear, he then ends up changing it to where if he can't be satisfied with his discovery, which again, he's asking for something he knows is impossible, then the only remedy is exclusion from testifying. You see what he's done here? You see what he's done? It's like the mental gymnastics and all of the false premises that you have to assume are true in the first place to get to where he's getting so that he can try to exclude ARCCA because there's no way to exclude them. I mean, he doesn't have any other way to exclude them. So that's what's happening. Ugh.
was information from ARCCA that would make clear the relationship between the ARCCA witnesses and the defense.
The relationship is
Back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCCA witnesses, if they're called, about candor, truthfulness, and full disclosure.
Oh my God.
And so while we've received some answers to our questions,
Lord.
we want a
Why?
full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but
So horrifying.
regarding this very issue about the relationship between the witnesses and the
Right.
defense. That is one viable option. My concern specifically is if they are
Well,
subject
no,
to a voir dire the day before their testimony, they're traveling from out of state, that they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these
Right.
items, I expect, would be in the custody and control of these ARCCA witnesses. There are a number of specific items which we sought.
So I just want to say to Annie's point, yeah. So was that at the hearing, another hearing? I'm trying to think back to that. So she was saying, I remember it being ruled that they could testify. I remember that too, but she's saying, but that it was going to be limited. So what and now that you mentioned it, so now I'm having flashbacks to something, and it would have been in a hearing where there was a change. Do you guys remember? There was a change from the first trial. Like, in other words, it seemed like, yeah, of course they're going to testify, but like, there was never, it seemed like what they would be able to testify to as far as the actual, like, their findings, right? Like, that wasn't going to be at issue, but the only thing that was being fought over was like, how are they going to talk about the third party, right? But now I'm having a thought that there was something that was different from the first time. I think hold on. Okay, here's what it was. Remember, okay, here's what it was. Here's where they were at. The Commonwealth wanted to bring them in for voir dire. And it was like, this is crazy because they've already been vetted as expert witnesses. There's no problem. And it was like, well, the voir dire is about the candor or whatever, right? And the Commonwealth wanted to bring them in ahead of the trial. And then what Judge Bev ruled was that she was going to try to this was actually a better idea, right? That they could be voir dire like the day before they testify, so that the defense doesn't have to like fly them in and put them up in hotel extra, right? That was what she had decided. That's what I recall, actually. I don't remember if there was going to be any limitation onto their findings or not. It maybe seemed that way. I'll see if you guys remember in the chat. But I remember that was the most recent thing, though, as far as the voir dire, was that they were going to do it right before they testify. So let me see what y'all are saying. Okay, that's right. Yeah, that's what I don't think there has yet been, though, any restriction put on what they can testify to as far as their findings, but it does, and she denied for them to be able to say the third party, or sorry, the DOJ part. So like, they're going to have to say, so in other words, it sounds like so far it's going to be a lot like what we heard last time, which is they can say third party, but they can't say which third party. And a lot of it should be pretty much the same. But the only difference would be that now there's an additional bit that they can be questioned about their candor to the court and their, who's paying them and all that. So that's kind of right. That's the reason. Right. And I don't remember. See, I'm trying to recall the voir dire, though. I think that's about the candor. Do y'all remember? The voir dire is about the candor to the court and the discovery business, right? Versus their findings and what they can testify to. If anything, the defense should be fighting for them to be able to get into causation. Because remember, Judge Bev has gone back against her own law that she made up. Like, that's the other thing. So with the crash daddies as well, right? They weren't able to, because they're not medical doctors, they were not able to get into causation, right? Just like Dr. Russell. So really, if anything, what should be argued here is like they should be able to testify to more than what they did last time, because Judge Bev has just changed her own law that she made up. Okay.
in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant.
Okay, so this is literally what we were just talking about. Let me back that up. So this is actually really funny. So we were discussing everything, and this is all super relevant here.
Communications, billing, emails,
Okay.
text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two
Literally,
things to
I'm glad this bothers you as well. I'll tell you what, he has a tick that he does. And I've pointed this out before. He literally just did it when I went to pause it. He takes them out and stacks them over and over again. And when he does this, he's like, I think two things. He does this when I've noticed when he does this, especially frequently, it's usually when his face is flushed as if he's like been a naughty boy. That's how I interpret this. Like something about, like, I want you guys to watch this. Something about his face and his speech. I don't know. I get the feeling that he's like a dog with a tail between his legs. And I don't know. Let me know what you guys think. But watch for the stacking of the papers. He just stacks them and then he'll reshuffle them and then he'll stack them again. And it has no point. It's really funny.
any new information,
It's like
any
a
new
coping
report.
mechanism.
We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Oh, hold on. I didn't go back far enough. Hold on. So he fusses with this, though. It is just so funny.
Discovery deadlines have passed some time ago. It would be inappropriate at this point to the ARCCA witnesses.
Here we go.
Notice from the defense,
Here we go.
there is some suggestion about the ARCCA witnesses potentially rebutting or commenting on Mr. Welch's testimony.
There's one stat.
Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to...
So I don't know, what do you guys think? There's times where there's a lot of them. It's just, it is really fucking funny. It is a whole thing. It's a whole thing. Yeah. Right? Yeah. Maybe he rephrased his argument. Yeah. So you'll notice, though, there's times in other hearings, guys. In fact, I think I have it time stamped because there was one time where it especially bothered me where he stacks loudly. It's like he stacks back to back loudly, and there's no point. He just reshuffles them and then he stacks loudly. It looks sort of like, sometimes it's like a nervous stacking, but then other times it's like an angry stacking, kind of like if someone were to bang their hand on a table. It's kind of like that, like he's stacking it to try to make it seem like he's making a point and he's like angry. It's like a loud, there's the loud stacking, like when he has a bunch of papers. It's really audible and really the obvious gesture. So it's just interesting. So it bothers me. I'm glad you guys aren't bothered by it. I'm bothered by it. But I will say it bothers me more because I've been noticing this for a lot longer, you know? So, yeah.
Order ARCCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCCA limited to the discovery that was properly provided before the discovery deadlines. Those are my 3 requests.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Breenan is now bringing up concerning ARCCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information.
Here's the thing. While this is a problem and it's really awful, really annoying, it's not the strongest argument to make. What I would do if I were them is if you want to file a separate motion regarding their late discovery, file a separate motion. But in other words, in terms of what he's arguing with ARCCA, this is not, in my opinion, the strongest argument is not, well, they've also been doing late disclosures. Like, that's just, you know what I mean? Like, if it's that much of a thing, file a thing, right? File something about that. I don't know. I don't like that he's starting with this. I think we need to stick to addressing ARCCA. Anyway, that's just my thoughts.
From their experts, the reports, amended reports, redacted reports, additional information.
Yeah.
Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice.
I'm glad that makes sense to you guys, because it's like way too big of a deal to go with the tit for tat thing, right? And honestly, that's what the Commonwealth does, and it's so annoying. It's like, come on, right? Address the actual issue.
Redacted reports, additional information. Both sides understand that discovery is an ongoing
naughty boy,
sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate there too. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. That's all I can say to that.
Let me hear that again. Are they going to engage in additional testing? Really? Hold on. What?
If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over.
I don't like that. What do you guys think? How do you feel about that? I'm like, that makes me nervous, because here's the thing. If this was the Commonwealth, it would be fine. But we know how it goes here, right? If it's the defense, this makes me nervous because Judge Bev loves finding, well, she doesn't even really need a reason to try to punish them, but don't give her a reason, right?
So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13. Another party says, we gave them to you. And then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is.
I need to back that up just a second. By the way, kids, I need to say, when you have a chance, I highly recommend, there was a members only live stream last night. You will love it. My mom, at Elon University, they had a concert and the theme was anthems of social change. And while you may not know some of these songs, since I know you don't have as much exposure to non-classical music, unless it's like certain genres related to certain things that you watch, like, like different like film scores and stuff. But anyway, but the message is really, really, really good. And what you will appreciate is that the students have to do all their own arrangements of these songs. And I think you'll really love it. And anyway, so highly recommend when you have a chance to watch that. My brother filmed it and we watched it live, but it's a good one. So, right. They may or may not. Yeah. They may or may not be doing additional testing or analysis. Yeah. It's a bit sketchy. I don't like that. That makes me nervous. Right. They can't exclude anything that might exonerate. Well, it's like, the thing is I feel like she's already been excluding stuff that could exonerate her. You know what I mean? So I don't know. It's different if the Commonwealth finds it, right? But if the defense finds it, I just feel like, see, that's different. That's not Brady, right? That's not, it's different. Like if the defense has found tons of exculpatory evidence, and I feel like a lot of it's not being let in. But if the Commonwealth finds it, that's different. Ugh. It was the concert official, you commented on it, the Elon Music Ambassadors, the anthems for social change from last night. So yeah, anyone that missed it, definitely check that out.
This is on what you filed. So this is not unusual. A party says, we asked for all 13. Another party says, we gave them to you. And then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
the
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCCA testifying. Let's just call it like it is.
So
That's what
address
he does
number
not want.
one, please.
I
Okay.
am.
Yes.
We have provided
Thank
on.
you, Jackson. Literally what I've been saying. And it's so funny because the whole time we're not trying to stop them from testifying. literally. Jackson, yes, sir, my hero.
I anticipated, and
You
then
can be my hero.
Okay,
baby.
so address number one, Mr.
the
Jackson.
number one issue that Mr.
Yes.
Brennan has anticipated and tried to prevent is ARCCA testifying. Let's
Yes.
call it like it is.
So Yes.
Address number one, please.
I
Okay.
am. That's what I'm doing, Your Honor. We
Yes.
provided on
Sir.
April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with.
I had a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things
okay.
that are.
I'm gonna lose my mind because this was cleared up. This, y'all, we watched the dude. We watched it at the time. We've also rewatched it from last summer, right? When they voir dired. We've gone back and looked at this. Literally, that was the only, because the reason we did it is because it was the only issue that Lolly had with the ARCCA dudes. Like Lolly's only issue was he wasn't sure who did what. That was cleared up. And then Lolly literally says, I'm satisfied. And I made a joke about it. I'm like, Lolly's satisfied. Great. So anyway, this was settled. This was cleared up. And then Judge Bev's like, I don't know who did what. You've got to be fucking kidding me. Why?
Normal cross-examination. Is that clarified any better? They said we. They talked about we did this. We did that.
Crystal
Well,
light
I
clear.
would disagree with that. Dr. Rentschler talked about what he did, which was
Yep.
more on the biological
I think
side.
there was a difference
Right.
between the
And
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Sure.
Right. Ms. Lou I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. That is on. That's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely. That is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Councilor Tebba?
Oh God. All right. Let's see here. Oh, okay. They take a break. Then they come back. Wait, what? What is going on? It says stream ended. What is going on? Hold on. That's okay. No, they come back. I don't know why it said that. Stream's not over. Don't worry, guys. That was weird. Why? Tell me why. Here we go. Perfect. We're back.
All right, so Mr. Jackson, you're saying that the ARCCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report. And that was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Breenan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice or the U.S. Attorney's Office was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was providing.
All right, so when
that's
did you
what we provided to them.
when did you do that?
I want to say March 26th or 27th.
That's fair.
I think it's in the motion.
Okay.
Additional discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCCA, including Dr. Welcher's reports and all of his findings, including the 140-page
Remember that. We read that
PowerPoint,
filing
et
notice
cetera. We
discovery.
wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCCA on March 26th.
All right, Mr. Brennan, I'll hear you.
comes with a stupid binder.
This is the very issue I've been concerned about since the beginning of this case. And
Oh,
I've made
God.
every effort to alert the court that I had a concern, the fact that I anticipated this very thing would happen. When I began this case,
I
beginning of
expect you to
October,
know
end of
that.
September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCCA. That's why I filed this motion for discovery. And when the defense responds, it's not in the possession of control. That's why these ARCCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCCA on the eve of opening statements, and then expect to come in with new opinions and information and reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCCA witnesses, they have their report. That is all pursuant to discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we
I
don't.
just wanted to point out he contradicted himself because his argument was it's not fair if we get it after opening statements because we can't tailor our opening statements to what the discovery will show. And he just said if we get it tomorrow or the next day or whatever, and he included days before opening statements. So
Need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
oh Lord.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st.
Kit
Nobody's
Smith,
been dragged
I'm with you on that one with the pet conspiracy theory. I'm with you on
in their
that one.
feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCCA
Spencer.
until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a two-week request. We asked for a two-week permission, or asked permission to engage them through a two-week request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Breenan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Oh, God.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welcher's PowerPoint were by exclusion.
Hypocrite.
Attorney Alessi had concerns about certain things in the report.
Oh, and
so
now
he
he's
took
back to
things
Alessi.
out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Breenan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCCA. That's when we received permission to engage ARCCA. That's when we provided the individuals at ARCCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing, and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to.
We had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct.
Great point from Fender. Did he just imply that CV is equivalent to the report? They've been making that argument, and Judge Bev has ruled on allowing, like, whenever the Commonwealth experts, and they've been talking about like how they didn't have a report. This has come up time and time again, where she, like, in her orders, she's been like going by the CV, like the CV is like sufficient. It shows that like that's how she was getting in these nonsensical Commonwealth experts, and it is insanity. So yeah.
But don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Breenan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right. So I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today. So what I need is the paper number. I think it's the Commonwealth's motion to exclude. But the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway, so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess?
Okay.
And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Recess, we'll jump ahead.
Put us back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay,
That's the audio, but there will be the visual with it that was aired.
okay. I was able to see the video.
Super.
Okay. All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant, and Detective Lieutenant Tully.
okay,
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay, can we address, is it something you need for your opening?
It's not.
Okay, all right, so yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out, all right?
Thank you.
Okay, so now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay, all right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay, so Jim, you have that. All right, I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Breenan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes,
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradel.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with that.
I love how Court TV put Turtle Boy's attorney. Oh my God.
Based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
But can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute that seeking to contact witnesses, seeking to question people is witness
Okay.
intimidation.
So just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry.
This is Turtle Boy's attorney because they're talking about him being, Commonwealth wants him to be sequestered.
What I said was, I'll hear you, Mr. Brennan. And you
Oh, I'm sorry.
But that's okay. I don't want to hear about
Got
the
it.
witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Okay. It is a right. Okay. Now, having said that, they might have said privilege because he's not actually a defendant in this case. You know what I mean? Like it's a right for a defendant, but maybe it's like it's a privilege if you're not a defendant in the case, is how I would interpret that. The only fan.
You are unmuted.
Court is back in session. You may be seated.
All right. Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right. So you're not asking for a Limine Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right. Thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
Alessi just allow me to make the representation on behalf of Mr. Kearney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Kearney to.
I want to hear that again. Yeah, so exactly. Officials putting in the chat about the Fifth Amendment. Right, exactly. And in a criminal case, so again, because I think he's saying privilege because this is not a criminal case against Mr. Kearney, which is Turtle Boy. If this was Turtle Boy's own case, right, for example, with the witness intimidation, whatever, then that would be, he has that right. But this is him being called as a witness for Karen's case.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the
She said right.
on behalf of Mr. Kearney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation. and leave it there.
She said right. So, I mean, I guess they can be used interchangeably, but it is true that the rights are far more substantial when you're the defendant, right? So.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Kearney to assert his Fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradle.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
FTR. Does anybody remember what that means? So Candace, he does not have any information. I think the whole point of this, my interpretation, is, you know, the Commonwealth has tried to act like the two of them have been conspiring or whatever. I don't know that there's no evidence of that. But also, I think that this is often done as a tactic to keep someone from being present in court. We've seen this even with Lori Vallow, right? And in this case, you know, like initially they had it with Gretchen Voss, and that's been sorted, right? But they don't want Turtle Boy present and reporting. So the Commonwealth, right? So by putting him on the witness list, then there's the sequestration rule. So it could just be, my interpretation is just a tactic to keep him out of the courtroom. So let's see if they come back. Franks, I'm not sure what you're referencing. He couldn't wait to testify. Did he say that? I don't know. I don't ever watch Turtle Boy.
All right. So, Mr. Brennan, I've just had a colloquy with Mr. Kearney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would, in fact, invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the two minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way that, where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask
Spencer,
the
that's
court to
funny.
consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy. And
it is something that we've done.
Right. Understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on this read, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, for the vote, please.
Hold on, let me hear the end of that again.
That's all. think I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on this read, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants brief, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so vote please.
So here's what I will say. There will be a number of filings coming out subsequent to this. Let me check and see if there's any already. Yes, Spencer, this is the retrial because the jury hung on the first trial. So it was a mistrial. I'm just going to see if there's anything that has come out already. By the way, we will be covering Lori Vallow here. I had that scheduled for 2:30. I might move that up. I wasn't sure how long this would go, obviously. Looks like Brennan's been paid more money, an additional $234,000. Let's see. I'm not seeing any new docs yet. I do have one that I grabbed yesterday. Let me see if I can find that. Yeah, here we go. Okay, just have to unshare, reshare. All right, so we do have this one. So this is, so we already saw from the Commonwealth, right? We covered this before, that the Commonwealth is going to intend to use chalks, as it were, or different, visual aids during opening statements. Again, this is different from last time. Nobody did this last time during opening statements. And I thought I would expect to see the same from the defense. Well, here it is. Defendant's motion and notice that the defendant intends to display visual aids to the jury during opening statements. Now comes the defendant and files defendant's motion and notice that the defendant intends to display visual aids to the jury during opening statements and will produce a copy of their proposed exhibits to the court in advance of opening statements for ruling on admissibility. Further, if allowed, the exhibits should be marked for identification so a complete record is made of all items shown to jurors in the courtroom during the trial. Additionally, defendant moves for an order that the Commonwealth specifically identify any visual aids, potential exhibits, or potential chalks the Commonwealth intends to use during opening statements and produce these visual aids to the defense in advance of use during opening statement. And remember, they use the word chalks in Massachusetts. Chalk is the same as a demonstrative aid. And we've talked about before, a demonstrative exhibit is a bit different because that can go back with the jury versus a demonstrative aid. It doesn't go back to the jury. It's just used to aid a witness during testimony, but does not go back to the jury. So demonstrative exhibit, they can offer that into evidence, right? And then it would, if there's no objections, then it would be admitted into evidence and then it would go back with the jury, which is a demonstrative aid, which is the same as a chalk. So hopefully that makes sense. So that's the only other latest filing we have here. So, right, exactly. Spencer says, oh shit, it's like a sequel to a good movie where it always bombs. Yep. But this retrial is going to be very different because of all the new attorneys, right? On both sides. It's going to be very different case. So, so I think what I will do, I've got Lori scheduled for 2:30. I think I'll keep that just because that gives us, they've been starting late oftentimes, but also that gives us a little wiggle room for when they, go to sidebar and whatnot. So we will do, I think I'll keep that at 2:30. And new attorneys, new experts. Yes, exactly. So if this, what I was going to do was I was going to have this redirect y'all if this, depending on how long this hearing went, but because it's over and we don't have any other new filings yet, then we will just come back for that at 2:30. Yeah, Lolly's just turned into a chair, which is fine. We're okay with that. So yeah, so anyway, but hopefully you guys can join us back here in like what, 40 minutes for Lori. And we will see what, it's entirely possible that the state may finish their case in chief today. I think they only have 3 witnesses left, so we're in the home stretch there. Will Lori pass 200 objections? Maybe, it's possible. What will happen on cross? Who knows? It's just, you know, usually the last witnesses, right, are going to be the most important for the state, which means the most damning for Lori. So how is she going to react on cross? It's anybody's guess. Will she get zapped? We'll see. So yeah, so that will be ensuing. Chaos will be ensuing shortly. I can guarantee that. Yeah, 3 witnesses left. Exactly. So I know one of them is like one of the lead detectives or whatever. I think he's going to be first up. So we will see. But yeah, hopefully you guys can all come back at 2:30. Setting your timer. Excellent. Love it. Love it. But yeah, so there we go. But love y'all. Y'all are the best. And see you guys here shortly for Lori. Squirrel out.